this is American Government, Monday, November 29th, 2021.
So, are you going to make like another exam slot so you don't have to stay through Thursday?
Nope. Would you take one and pass them down? Now, what I've done is, you'll notice at the top of the notes.
Okay, hey, can you wait for Sydney? She's about to be here.
Well, I've already started the camera.
Well, she's about to be here.
Well, we can start and you can catch up. So notice the exam is on Thursday from 12 till 3, which means you don't have to get up at 8 o'clock in the morning. Now, I made a couple of changes here. The notes here today include everything that were included through last Monday's notes. I have dropped from the syllabus, are you listening? I have dropped from the syllabus chapters 4 and 5 from the Wilson text. So what we'll end is, so what I've done is we only got through part of Marbury v. Madison, which was from last Wednesday, the Wednesday before. So I put all the notes together in one convenient place. And this will take us to the end of the class then, through on Wednesday. So we'll finish with Marbury v. Madison. We'll discuss the development of the judiciary and then the main controversy between different judicial philosophies. So if you notice, the notes are separated by a horizontal line on the second page, third page I should say, and the fourth page. So that's, so again, drop, yes?
I have a question before you start. Okay, do you have PRQs for December 1st, or did it just not turn out?
No, they're on here. Except on the PRQs, you should drop from the PRQs chapters 4 and 5 of the Wilson text. So did that help? All right. So is that clear, everyone? So you can drop that from the syllabus. That's on the PRQs. That would have been for. Oh, because on the original schedule, I just left. We were supposed to finish with this, with the last part of the judiciary material today on chapters 4 and 5, but we fell behind. So, if the original schedule, it just said Wednesday was a review. So I'm just, that's no longer a review, that's going to be the end of this material. And so that means drop chapters 4 and 5 from the Wilson text, from the syllabus. That was the material originally for November 29th. Is that clear, everybody?
Do I need to drop everything from November 29th? Or just the text?
Just chapters 4 and 5. That's what I think was the only thing that was assigned for that day. Is that clear?
Sydney, do you need a pen?
Yes, sorry.
I got her, I'm right.
There are worse things in the world. So did you get her a note? Oh, how nice of you already. Good. All right, so let's make sure we're all in the same place. The final is Thursday, December 9th from 12 to 3. I sent an email about that. Please note that. Today's notes cover the material on the judiciary that we got behind on, including, and we only got part of the discussion on Marbury v. Madison, so we'll pick up there. And then that includes the notes from last, on the schedule. It's up through Friday the 26th, I think. So the material that was for December, for November 29th, which was Wilson chapters 4 and 5, you can drop from the syllabus. So we will finish on Wednesday with this material, and if you notice, the dates for today are both today and Wednesday. So this will take us to the end of the course. Any comments or questions?
It's hot in here.
Yes.
Okay, so we don't need these PRQs. I just want the
Send
Wilson
it, I
chapter
don't have them in front of me, but yes. So just let me check before
Can I help you? Oh,
Can you tell me the dates that
I'll
it's
just
off,
get it,
because I don't have mine with me.
as soon as I look, yes, thank you very much.
no, no, no.
So, for Monday, November 29th, Wilson chapters 4 and 5, where it says don't need these,
Mm-hmm.
we're crossing those out.
Okay.
So we will end with, so where do we end with? With the notes from Monday, November 22nd, Bork and Brennan. And we'll probably finish that on Wednesday. So what these notes are, thank you. These notes are, and change the date for the exam till Thursday, December 9th, at, from 12 to 3.
Okay.
So, here's where we had gotten on Marbury v. Madison. We'd gone over the parties, who they were, what they did, and we've just begun the legal questions. So, Marshall lists 3 legal questions, and then I list the unlisted but most important legal question. And that, as you're going to see, is can the Supreme Court declare a law of Congress unconstitutional? So, question number 1. Does Marbury have a legal right to his commission? What's the answer to that?
Yes.
Why? If you remember in our discussion of the party, had he been nominated by President Adams, did he get, does that mean the commission was his at that point?
Yes.
No, because in other words, what are the steps? How do you get to be a federal judge?
You get nominated in the.
All right, the president nominates, right?
And
According to
then
Article in Section 2, then what happens?
Doesn't,
Ratifies or doesn't ratify, right?
okay.
And then what happens?
Doesn't someone have to approve it?
Here, I'll attach you, this is the clause in the Constitution that this refers to. Article 2, Section 2, Clause 3. He shall, this is the president, so let me back up. He shall have the power by and with the advice of the Senate to make treaties to providing 2/3 of the senators present concur. And he shall nominate and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for. So, Marbury's, remember they had just created all those federal judgeships, and Marbury's was a federal judge. So the Constitution says, how do you get to be appointed? Who nominates you? Who nominates you?
The president.
The president. Then it goes to the Senate, and the Senate either agrees or disagrees, right? Then what happens? This is from Section 3. He shall from time to time give to Congress information as to the state of the Union, and recommend to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses, or either of them, and in case of disagreement between them with respect to the time of adjournment, he may adjourn them to such time as he shall think proper. That has been very rarely invoked, by the way. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and, this is the clause that's relevant, he shall commission all the officers of the United States. What does it mean to commission? It means that he puts the seal of the United States on it, and at that point, once the seal of the United States goes on that document, the process is completed. There remains only one thing left, and that's what? To deliver them. Now, in this case, who was left responsible for delivering them? The former Secretary of State. Who was who? John Marshall. Who, one of the last things that President Adams did was to appoint John Marshall, the Secretary of State, as the incoming Chief Justice of the United States. Then, President Jefferson won the election. He appointed James Madison as his Secretary of State. And in all the hustle and bustle of the last minutes of the frenetic leaving of office in 1801, John Marshall left 4 of the nominated, ratified, and sealed commissions, left 4 of them on his desk. He just didn't get to them. James Madison then, who was appointed as Secretary of State, came in, found them, and took them to the new president, who was who? Who was the new president in 1800, 1801?
Thomas Jefferson.
Thomas Jefferson. And Thomas Jefferson said, don't deliver them. File them in the circular wastebasket. I don't know if he actually said that. Then, William of Marbury, who was sitting around waiting for his commission, and which never arrived, he knew that the choke point was the Secretary of State's office. So what did he do? He filed suit in the Supreme Court of the United States. Now, as you're going to see, well, we'll explain the legal writ in a minute. So, does he have a right to the commission? Now, to say that it's a right to the commission, it means it's his property. At what point did that commission belong to Marbury? Was it when the president nominated him? No, because what could have happened?
It could have been disapproved by the Senate.
Yeah, the Senate, all right, was it when the Senate approved the nomination?
No.
Because strictly taking at that point, the president could still have changed his mind. At what point did the commission become Marbury's property?
When the seal was on it.
There you go. Now, it would be as if literally you had a check in the mail and the postal delivery person just saw it was a check and decided, I'm not going to deliver this check. Do you have a right to that check? Is that your property?
Yeah.
Now, it's actually a criminal offense for mailmen not to deliver mail. But you could say, if you knew that a check was coming and you knew the postman had withheld it, well, in addition to taking, actually you would be arrested and put in jail for that, but you could sue him for it, and that's exactly what Marbury did. He sued Madison. Now, who is the suit really against? And this is part of the opinion of the case. This is why this is really Marshall performing judicial jujitsu, judicial judo. Who is the suit? Who really caused the problem?
The Secretary of State.
Whom was he acting under the orders of?
Jefferson.
So in other words, this suit was really against whom?
Jefferson.
And you're going to see Marshall knew exactly what to do. This was a brilliant case. He was a brilliant man. So does he have a right to the commission? Yes. Is there a remedy for his injury? Yes. All judicial orders are called writs, like a writ of warrant, a writ of habeas corpus, etc. And you're going to see the remedy for this is a writ of mandamus. Now, if you've had Latin, or if you haven't had Latin, the root of this word is mandare, to command. Mandamus, mandamus, as we say in English down here in the South, mandamus means we command. A writ of mandamus is a typical judicial order. Let me give you an example of another one. A writ of injunction. A writ of injunction is a judicial writ or issued by a judge or a court against an official to stop doing something. By the way, not just an official. Sometimes if people strike, like if workers strike but it's an illegal strike, the company can go to the court and get a writ of injunction against the strikers to stop the strike. Here's another example of a writ of injunction. So an injunction is a negative command. Don't do that. In 1952, the steel workers of America went on strike. And President Truman ordered the Secretary of Commerce, Sawyer, to seize temporarily the steel mills and force the workers to go back to work. Because what were we in the middle of in 1952? What war?
World War II.
No, World War II was over in 1945.
Cold War? The Cold War?
Part of the Cold War. This is the hot war. The Korean War. For your information, by the way, the Korean War is one of the deadliest wars. So was Vietnam with 57,000 dead. But the 3-year Korean War led to 33,000 Americans killed in South and North Korea. So we were in the middle of the Korean War. And where do weapons come from? What are they made out of?
Metal.
They're made out of steel. But the steel workers went on strike. What would they do to weapons production?
Stop it.
And therefore, as his authority commander-in-chief, President, this is one of the cases I didn't ask you to read, but it's a companion case, the Curtis Wright case. Then President Truman issued an order to the Secretary of Commerce, Sawyer, to seize the steel mills. The steel mills, led by Youngstown Sheet and Tube Steel Mill in Youngstown, Ohio, immediately sued the Secretary of Commerce. This case, by the way, is called Youngstown Sheet and Tube v. Sawyer in 1952, for a writ of injunction by the Supreme Court against the Secretary of Commerce to stop the seizure. And within 3 days, the Supreme Court heard the case, and indeed, that's exactly what they did. They issued a writ of injunction, which is a negative command to the Secretary of Commerce to stop the seizure. So, a writ of mandamus, that is to say, a writ of we command, is a positive order. So if a writ of injunction tells an official, don't do it, what does a writ of mandamus do?
Do it.
Do it. So is there a legal remedy for his injury? Yes. It's a writ of mandamus. a judicial order to abolish. Does that make sense? That's what a writ of mandamus is, and you'll see where this comes from. That's the second legal. You got that? The third question he asks is, now remember, these are the three questions he asks. I'm arguing there's a fourth legal question which he doesn't state, but is actually the most important question. Can the Supreme Court, this is his third legal question, can the Supreme Court issue a writ of mandamus to the Secretary of State? And the answer to that is
Yes.
no.
No, that's what.
Now why? It turns out that if you say, well, why did Marbury think he could get a writ of mandamus from the Supreme Court? Because Section 13 of the Judiciary Act of 1789 gives the Supreme Court the authority to issue writs of mandamus. A little bit of background. The Constitution was ratified in 1788 and went into effect on March 4th, 1789. That's when we started being governed under the Constitution. One of the first things the first Congress did was set up the executive branch. The 5 departments of the executive branch. The Department of War, the Department of State, the Department of Interior, Department of Justice, and the Department of the Treasury. The second thing they did was to set up the judicial branch. Because remember, the executive and judicial branches, the only executive part of the executive branch is the president and vice president that's mentioned in the Constitution. Congress creates all the other offices and the president appoints them, etc. Or with the civil service, as we saw. The judicial branch, it says, here's Article 3. The judicial power shall be vested in one Supreme Court and in such inferior courts as Congress shall from time to time establish. So the Constitution mentions the potential judicial branch, but Congress actually had to create it. So, the Federal Judiciary Act, 1789, creates the judicial branch. It creates all, and we're going to come back to this in a minute, for the structure of the federal judiciary. The district courts, the circuit courts, and then it creates the positions on the Supreme Court. Note, as we'll see, Article 3 does not say how many justices are on the Supreme Court. That's still controversial, even today, as we'll see. But then the other thing that the Federal Judiciary Act did was to determine, besides the Constitution, in addition to the Constitution, the jurisdiction and the way that courses get up to the Supreme Court. So, I'm going to read Section 13, no, better yet, let me reverse the order that I did it in my notes. Because if something is unconstitutional, if a law is unconstitutional, just tell me what that means. What does it mean to say a law is unconstitutional?
It conflicts with the Constitution.
Yeah, in other words, this is a statement from a 20th century jurist called Learned Hand. What a great name. And he said, what happens when the court declares a law of Congress unconstitutional? Well, they set the Constitution down, and then they set the law right next to the Constitution, and if it doesn't match, out goes the law. Now that's a pretty common sense understanding. It's a little more complicated than that, of course. But my notes quote from Section 13. Better, let's go to Article 3 and see what the Constitution says. So obviously, the reason Marbury couldn't get a writ of mandamus in the Supreme Court is Marshall thought that the law that granted him the right to do that was unconstitutional. Let's start with the Constitution. If you turn to page 2 of the notes at the top. Here, Sophia, where it says, here is Article 3, Section 2, Clause 2 of the Constitution. Read that.
Clause 2, in all cases affecting ambassadors, other public ministers, and councils, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction both as to law and fact, with such expectation, and under such regulations as Congress shall make.
Tell me what this says in common sense language.
That the Supreme Court only has jurisdiction in certain areas where...
What kind? What kind? So, first of all, it creates two kinds of jurisdiction. What two kinds of jurisdiction?
There's appellate jurisdiction and original jurisdiction.
So what determines now what's original jurisdiction mean?
Where the case is originally brought.
Yeah, and that means for most cases that come out of the Supreme Court, almost all of them, 90 million% of them, are appellate cases. which means they start at some other court and come up to it. Is that clear?
Mm-hmm.
But there are a few cases, the Constitution says, which can originate. That is to say, the Supreme Court is actually the trial court. You understand that the Supreme Court tries very little cases, very few cases. Most of the other cases they hear, as you see, are appellate cases that are coming up that have started in a district or a circuit court, or a state court for that matter. So, what are the cases that can originate in the Supreme Court? What are they?
Those involving ambassadors, public ministers, and consuls, and where states are party.
Okay, so that is called an enumeration. And like other enumerations that we've seen in the Constitution, what is the implication of an enumeration?
That includes everything.
And what it is not listed?
Is not included.
So in other words, can Congress expand the original jurisdiction of the court?
No.
No. So by the way, you should understand what these are. Ambassadors, public ministers, and consuls. They are actually all in the same class of official. They are officials of other governments other than the United States. An ambassador is the chief foreign official from another country. Public minister means like a subordinate, like a semi-ambassador or a deputy. And consuls are like limited ambassadors for particular purposes. For instance, in Spartanburg, the Swiss, the Germans, and the French used to have all consuls here in Spartanburg. Why?
Why?
Because it turns out there is more international business per capita in Spartanburg County than in any other county in the United States.
What?
I'll say it again. There is more international investment in business in Spartanburg County than in any other county in the United States. For instance, what big tire company is here? Michelin. What big auto company is here? BMW. And,
Oh, yeah, that's true.
but if you notice, if you go above 85, that's sometimes called the International Court of Business. Many of those companies are all Swiss, German, or French companies. Now, as of the last 10 years, all three countries have eliminated their consuls here in Spartanburg and they moved them to Atlanta. Why? Because there are issues like with respect to certain aspects of commerce where you don't have to go to the French embassy.
Oh, I was gonna say because Spartanburg's ghetto, but.
Well, in other words, it's more convenient. You don't have to go to the French embassy in Washington. You can deal with these issues locally. So that's what that's what they're all essentially for officials of foreign countries. Why? And then the fourth category is where a state of the United States is a party. Why would you want these four kinds of cases to be able, not that they have to, but they can? Why would you want them to be able to originate on the Supreme Court level?
Because ambassadors, number one, like if it deals with foreign countries, you would want to deal with that federally because they have more connections and like knowledge of foreign countries.
That doesn't mean to say that a case involving an ambassador or problem couldn't start at a lower case or even a state. But obviously, when you're talking about a foreign country, you're representing the United States as a whole, right?
Mm-hmm.
So it makes sense to have the Supreme Court of the United States be the court of trial, and where a state is a party.
Because you don't want another state having bias, like you wouldn't want that state or another state dealing with it.
That's right. Even though the federal district courts generally fall within state boundaries and are district courts, they're federal courts, they could still be biased. Here are two examples, by the way. North Carolina sued South Carolina over the border because the way that the borders were drawn is actually 10 miles difference once. And so North Carolina sued to have the border restored to what it considered the border, and it won. Also, Minnesota sued Idaho. Not Minnesota, Montana sued Idaho.
Minnesota is not near Idaho.
Well, there are different reasons, but for instance, river issues often cross state boundaries. This had to do with the apportionment of a representative in Congress because Idaho and Montana actually come very close in population. And so that's why so you're right, you want a state to be able to go right to the central court of the United Nations. Now, what about appellate jurisdiction? What determines the court's appellate jurisdiction according to this section of the Constitution?
I guess it would move through smaller courts, like without a decision or maybe without the
And
right
who controls
jurisdiction.
that?
The judge?
No, look, it says right there.
Oh.
State.
In all other cases before mentioned, the
Oh, they
Supreme
are
Court
appealed.
shall have appellate jurisdiction, both as to law and fact with such exception, and as Congress shall
Oh,
make.
Congress makes the exception.
So I have to say, let me give you an example of how this might work. When Roe v. Wade, interestingly enough, you should note, by the way, there's a Mississippi case coming up this week in which the court may actually overturn Roe v. Wade. Most of you know what Roe v. Wade is. The
Yes.
1973 case which legitimated abortion. There's actually a Mississippi law which clearly violates that. So it is speculated that with the 6-3 conservative majority, that for the first time they may have a sufficient majority to overturn Roe v. Wade. Some people.
So how can they can overturn it by what, like the nullification process? They're saying that Roe v. Wade was unconstitutional?
Well, who passed Roe v. Wade? The Supreme Court, right?
Yeah. So that's-
Therefore, it's just like any subsequent legislature can repeal an earlier law of any legislature, right?
yeah.
Any subsequent president can repeal the executive order of a prior president.
So they try, wait, sorry.
Unless, by the way, a judge says you can't.
So are they gonna try to, like, you said they're gonna try to overturn it in the Supreme Court or just in, what state were you talking about, Mississippi?
Mississippi passed a law this last year which severely restricted access to abortion based on, I think, the detectable heartbeat of the fetus. Roe v. Wade divides, if you've ever read Roe v. Wade, it divides the pregnancy into 3 trimesters.
Right.
And the first 3 months, the second 3 months, and even though the court has more or less abandoned that framework, it replaced it with a viability framework. You know what viability means?
A viable pregnancy?
Yeah, well, what does viable mean? When something is, what is the root of viable? What does the word viable mean?
Life.
Capable of living.
Yeah.
So it kept the basic thrust of Roe v. Wade and modified it to viability. So it tends, so when does a fetus typically viable?
Like 6 weeks?
No, actually.
Like, it's shorter than
Viable
that.
means what?
Oh.
Living.
That it can live outside the womb.
Oh, so like,
Isn't it like 20?
It's very close to 6 or 7 months. Because a friend of mine just had 2 little granddaughters, identical granddaughters, twins, born 2 months premature. And they just barely survived, but they survived in incubators and everything, and now they're thriving little girls. So about the 6 or 7 months, how many weeks is that? So
24,
28.
So viability is right around there. Mississippi's law limits the heart at the first detectable heartbeat, which is about 6
5 to 6
weeks, I think. Is that
Yeah.
right?
I think it's 5 to 6.
So it clearly violates. It clearly violates the standard in Roe v. Wade. What people are hoping, and this is why they passed the law, they knew that it was going to conflict, and they would have to go up to the Supreme Court. And so the question is will the Supreme Court sustain Roe v. Wade, or will they overturn it?
So if they overturn it, does that make abortion state by state again?
That's exactly what it means.
Okay. Sorry. I
Because
need to clarify.
because this issue, like many other issues, were regulated state by state. So if the Supreme Court overturns Roe v. Wade, it means that after this point, that abortions will be legal or illegal or restricted or permitted, and however, how much within each side on a state by state basis. That's what it means. Now, why can they do that? Because who decided Roe v. Wade? The Supreme Court. So a subsequent Supreme Court can and this is called, by the way, precedent. It can either uphold a precedent, in which case it maintains it, or it can overturn it, in which case it abandons it and charters a new court. So, who controls, just to make sure, so what determines the court's original jurisdiction?
The Constitution.
The Constitution does by listing it.
Yes.
What determines the court's appellate jurisdiction?
Congress.
And the reason I mention that is when Roe v. Wade was first passed, and for that matter, when Brown v. Board of Education was heard in 1954, which outlawed state segregation, there was so much resistance to that decision by southern states that southern senators wanted to pass a law that took school segregation cases out of the Supreme Court's appellate jurisdiction. In other words, any case that dealt with segregation in schools, according to this law, would no longer be part of the court's appellate jurisdiction. Now, can Congress do that?
No.
What does it say right
Yeah,
there?
they can, I mean, but they didn't.
Yeah, but the law didn't pass. Question.
Okay, so this might be dumb, but I shouldn't know. So how do you, who appeals to get cases from where they are to the Supreme Court?
That is in Chapter 12 of the Wilson text.
Oh, okay.
So if you haven't read chapter 12 of the Wilson text, we will come to that.
Okay,
The specific answer to your question, not to embarrass you,
it's okay.
is almost all cases to the Supreme Court are now appealed to it through what is called a Writ of Certiowari. This is discussed in chapter 12. Certiowari means we certify to hear the case. And typically, when 4 of the justices of the Supreme Court, because, again, in the 1980s and 90s, the Supreme Court reached its peak caseload of about 300 cases, although they could not do it. And over the last 3 decades, the court has generally reduced its caseload to about 150 to 200 cases a year. So basically, a case is appealed up to the court, and the Supreme Court decides to take it or not to take it based on that writ. So that writ is called certiowari. It means it is certified by us, or it is certified. And that's when 4 of the sitting justices on the court agree to hear a case. That is how cases come up to the Supreme Court. Does that make sense?
Yeah, but I'm saying, like, who brings it in front of them?
Oh, it depends on, well, okay. It depends on who loses in the lower rung of courts. The first name of a court case is always the party bringing the case, the plaintiff in the case.
Okay.
If it's if it's a criminal case on a state, it's usually Bernstein versus the people or something like that. That's what most criminal cases are called. If it's a U.S. criminal case, it's the U.S. If it's a civil suit, then it's the same way. So, in other words, go back to Curtis v. Wright, U.S. v. Curtis Wright. In the original district case, court case, when U.S. v. Curtis, the United States lost, then they appealed the case up to the circuit court. And the name of that case was U.S. v. Curtis Wright. They lost on the circuit level too. So by the time that court case came up to the Supreme Court, it was called U.S. v. Curtis Wright because the United States had lost on the prior 2 levels and was bringing the case. So whoever loses a case on the lower level is the one, if they so decide.
To appeal.
So for instance, the Biden administration lost in the 5th District Court. They were sued by 15 states about the vaccine mandate, and they lost. So my guess is, and they appealed it up to the circuit court, and they lost there. They have not yet appealed it. What that means, by the way, that the mandate that was supposed to go into effect in January is actually, there is a writ of injunction on the Biden administration and OSHA to enforce that. Now, what's the decision left to the Biden administration? In other words, the Attorney General, Merrick Garland, or OSHA, depending on who's going to represent the administration. What will that court case be called? So what do they have to decide?
If they're going to appeal it again.
Yeah, so in other words, and my guess is they won't appeal it. Because in all likelihood, it will be upheld.
Yeah.
So in other words, so who would bring that case would be the United States. So it would either be U.S. v. whoever the name of the case is, the states that primarily representing them, or OSHA, or even Garland, who's the Attorney General. Does that make sense? Did that answer your question?
Yeah.
So, that's the Constitution. Now this gets a little complicated. So, will Sydney, you're so good at reading. So go back to the first page. Now let's read Section 13 of the Judiciary Act of 1789. Now I have bolded and italicized the part that Marshall declared to be in conflict with that part of the Constitution. So, Section 13 of the Federal says, here is Section 13 of that law, Section 13.
Okay. And it be further enacted, the Supreme Court shall have exclusive jurisdiction of all controversies of a civil nature, where a state is a party, except between the state and its citizens, and except also between the state and citizens of other states or aliens, in which latter case it shall have original but not exclusive jurisdiction, and shall have exclusively all such jurisdiction of suits and proceedings against ambassadors or other public ministers or their domestics or domestic servants as a court of law can have or exercise consistently with the law of nations. An original but not exclusive jurisdiction of all suits brought by ambassadors or other public ministers, or in which a consul or vice consul shall be a party. And the trial of issues in fact in the Supreme Court and all actions at law against citizens of the United States shall be by jury.
And that has been very rare where the court acts as a trial court where there's a jury appointed. Now, let's see what this did. What it did was it took original jurisdiction, the category established by the Constitution, and divided that into two categories, exclusive and original. Original means it can start in the Supreme Court. Exclusive means,
It didn't?
no, it has to start there.
Oh.
So it doesn't, now note, it keeps the same categories of the Constitution and just refines them. Now, then it goes on, and this is the part that Marshall declared unconstitutional. Again, this is not bolded and italicized in the original. I did it for your understanding. Continue.
The Supreme Court shall also have appellate jurisdiction from the circuit courts and courts of the several states in the cases herein after specially provided for, and shall have power to issue writs of prohibition to the district courts from proceeding as courts of
Admiralty, Navy courts.
there you go. And maritime jurisdictions and writs of mandamus in cases warranted by the principles and usages of law to any courts appointed or persons holding office under the authority of the United States.
So what did this part of the law do? It granted to the court the authority to issue writs of mandamus to whom?
To officials of the United States holding office.
And what was James Madison?
An official of the United States holding office.
So why did Marbury bring his suit to the Supreme Court? What did he want? He wanted a writ of mandamus. What told him he could get a writ of mandamus from the Supreme Court?
This thing.
So, how did this, so explain to me, how did this conflict? Now, I explain how it does, but just on first reading, why did Marshall hold that this part of the Federal Judiciary Act of 1789 conflicted with the Constitution, therefore was unconstitutional? What did it unconstitutionally do?
It added another party to where cases can originate in the Supreme Court.
By giving it the authority to issue writs of mandamus. Now, it says it can writs of mandamus to any courts appointed. What does that mean? That means if a case came up to the Supreme Court, the court could issue a writ of mandamus to a lower court to order in a certain way or retry a case or something. But it also said it could issue writs of mandamus to officers of the United States. And that is what that's what the Secretary stated. So what's the problem?
That this case shouldn't have originated in the Supreme Court?
Well, there are two ways to answer this. Marshall held the law unconstitutional because he held that it added a party of added a set of parties to the original listing. So you all understand his reasoning.
Yes.
Technically speaking, then, what should Marbury have done?
Started in a lower court?
Yeah, and then appealed it up. There's every evidence that actually they conspired with. They arranged actually for Marbury to bring this to the Supreme Court so that he would lose it, so that Marshall could declare a law of Congress unconstitutional.
Well, like somebody basically played him kind of?
Well, he did get he actually lost, and you could say what he should have done is he should have appealed it up because then it would have been consistent with the law. Most people think that Marshall stretched to declare the law of Congress unconstitutional for two reasons. Because had he ordered, what if he had ordered a writ of mandamus to Madison to deliver the commission? What do you think would have happened?
He would have done it?
Well, who told him not to do it?
Jefferson?
So clearly, this wasn't just a writ of mandamus to the Secretary of Chief Court. This was an order, a potential order to whom?
The president.
And what do you think Jefferson would have done?
Ignored it.
Flipped them off.
He would have flipped them off. And what would have happened to the authority of the court had... So, by the way, I want you to know, in the rest of the opinion, if you look, he argues, that this was clearly a wrong, so clearly he's actually spanking the hand of Jefferson.
Oh.
But, declaring that he did something unconstitutional by depriving... But, he found a way of not issuing a direct order to him, which seems as if they lost the case. But in doing so, what power did he claim in not issuing the order to Jefferson?
What power did he what?
In other words, you could say on the question of ordering Jefferson to do it, he avoided doing it. Therefore, because he knows what Jefferson would have done.
He'd be mad.
And he would have refused to obey the order. After all, isn't the Supreme Court, aren't they co-equal branches of government?
Yeah.
Now, I want you to know that today, generally speaking, if the Supreme Court orders the president to do something or not to do something, it is part of our settled law that the president obey. But at that time, and what we're about to read, Jefferson did not think the courts had this power. And how would Jefferson have maintained that argument? By doing what? By ignoring the court.
Wait, so you think, sorry, last question. So you think if Marbury would have started in like a district court or something lower, he would have won?
Well, first, what's the answer to the first question? Does he have a right to commission?
Yeah.
Does he have, and is the solution to his problem a mandamus ordering the Secretary of State to do what he should have done?
Yeah.
Yes. But is it a mandamus from this court? And it's only because Marbury took the court originally that he was treating this as original jurisdiction. Now, the consensus of opinion is what should, you could say Marshall would have had two alternatives. He would have said to Marbury, you come to the wrong court. Start in a lower court and bring this up on appeal. But that would have meant, what would he eventually have to do?
Come up to the Supreme Court.
And what would Marshall have had to have done?
He would have had to issue the writ of mandamus.
To whom?
To Jefferson and Madison.
To Madison, meaning Jefferson, and then what would have been the outcome?
Marbury would have been a judge.
And the court's authority would have been damaged forever. Does that make sense?
Yeah.
Instead, he didn't order Marbury. He actually then tried the case, and he held that when it came to original jurisdiction, the law giving the court the right to do this was unconstitutional. So in avoiding the conflict with Jefferson, what did he in fact establish the broader power of the court? To declare a law of Congress unconstitutional. This is very tricky, and most law schools don't even go this far into the case. Now, that means there is a fourth legal question, which he doesn't say at the beginning, but is at the heart of the question. Can the Supreme Court declare a law of Congress unconstitutional? That's really the fourth real question. You see on my notes there? And Marshall answers this case. So, can the Supreme Court declare a law of Congress unconstitutional?
Yes.
Yes. Why?
Because it can.
All right, now here I broke his argument down to you in outline form. Notice, whenever Marshall decided an opinion, he usually did it on two grounds. He would usually give a history of the problem, then he would give the theoretical answer, and then as you're going to see, he would find the answer in the text of the Constitution, so let's do that. So, can the Supreme Court declare a law of Congress unconstitutional? It turns out there's a first and a second part of theory to this. What's the A that I list there?
Oh.
Theory 1.
Yes, it's implicit.
Well, what's the question?
Oh, can a law of Congress be unconstitutional?
Now, by the way, as you're going to see, Jefferson had a different answer to that, potentially. In other words, what would be the alternative to saying a law of Congress can be unconstitutional? Could be. That every law that Congress passed
It's constitutional.
you would just assume. Marshall says, no, you can't have that. It's in the very notion of a limited constitution, a written constitution, that a law of Congress be potentially unconstitutional. Why?
Because
if every law of Congress was constitutional simply, that would mean, here, I'll answer it this way. If every law of Congress was presumed to be constitutional, would the Constitution therefore operate as a limit on Congress's power anymore?
No.
But isn't the premise of a limited Constitution that all the departments of government are limited by the Constitution?
Yes.
So, do you understand for Marshall, the first question you have to ask is it theoretically possible for a law of Congress to be unconstitutional? He says yes. In fact, it has to be theoretically possible, or else we don't have a limited Constitution. It's like the British Constitution. A law of Parliament can change the British Constitution, and has many times. So, do you see the first part of it?
Yes.
Is it possible for a law of Congress to be unconstitutional? Yes. What's the second part of the question, though?
Can the Supreme Court make that judgment?
Those are not the same thing, as you'll see. And so here you see Marshall replicating the argument for judicial review that Hamilton makes in Federal 78. So, Sammy, if you would read after that. So theory 2, part 2. Can the Supreme Court make this judgment? Yes.
The function of the judiciary to say what the law is in specific cases.
In other words, what is the task? What do the judges do? They decide cases, right? But in deciding the cases, we saw this many times, they often have to do what? When a law applies to a particular case, it's not only does the judge have to decide the case, he has to say what? He has to interpret the law.
Yes.
So judge, if you think about it, the judicial power is actually two separate things, but are inherently linked. They decide cases, but in doing so, they have to interpret the law. You can't get around it. He says, and it's the task of the courts to say what the law is. That's where we are at this point. Go ahead.
If two laws collide, the judiciary has to decide which controls decides the case.
Do you remember that argument from Federal 78?
Yes.
How Hamilton does that? First he starts out with two laws of the same legislature, then he goes from a superior to superior, and the last one, and this is where we come to this. And so what's the conclusion? So if two laws apply to the same case, who has to decide what they mean and which controls the case?
The judges.
The judges do. They can't avoid the test. It's inherent in it. What happens if one of the laws comes from a superior authority and one of the laws comes from an inferior authority?
Yes.
Clearly, what do the judges have to do in that case?
Go with the superior.
And there you go. So if you want to finish that, if judges are to regard, that is to say, look at and interpret.
If judges are to regard or respect the Constitution, they must give it precedence.
So do you see, it's the same theoretical argument that Hamilton makes in Federal 78. Now, Marshall always gives what he considers to be the supporting text in the Constitution. And here it is. The first thing he quotes is Article 3, Section 2. Tiffany, do you want to read that?
I would not like.
I will.
All right, we'll go back to Sammy.
Clause 1. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States and treaties made or which shall be made under their authority.
Actually, enough. So, in other words, what does that clause tell you, according to Marshall? The judicial power, which means where judges in the federal courts have the right to make a decision, right, shall extend to all cases in law and equity, what?
The laws, under the Constitution, the laws of the
So what does that clause tell you? Can the Constitution be used as a law in a court case?
Yes.
So that's exactly what this clause tells you. Because if a case can arise under the Constitution, isn't the Constitution saying this Constitution can give rise to a court case?
Yes.
And if it can, and that means it can be used as a legal standard in a court case. Everyone got that?
Yes.
Second, Article 6, the Supremacy Clause. Go ahead, Sammy.
This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding.
So, not only does the Constitution in Article 3 say this Constitution can be a legal standard interpreted by judges in a case, what does the Supremacy Clause tell you?
It's the supreme law of the land.
And it takes precedence over all other law, including, by the way, all treaties and laws of the United States. So the Constitution expressly says what is superior to a law of Congress.
The Constitution.
And then, by the way, that a law of Congress is superior to what?
The laws of lower.
The laws of the states.
Yeah.
So what the Supremacy Clause does is set up a pyramid of authority. That's why I call it relational when we studied it. At the top is the Constitution. and the second tier is laws and treaties of the United States, and the third are laws and treaties and Constitution of the state. The last text he gives as a support is Article 6, the Oath of Office from Clause 3. You can go ahead again.
The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states.
Does that include the officers of the Supreme Court?
Yes.
Go ahead.
Shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States.
So Marshall says, who takes an oath to support the Constitution? Everybody does,
Yes.
but including us. So, if the Constitution can be used as a law in a case, and if the Constitution is the supreme law, and if judges of the Supreme Court are bound by oath to support the Constitution, what must be the conclusion? That when a law of Congress conflicts with the Constitution, what must the Supreme Court do?
Appeal it, basically repeal it, that say it doesn't.
Now, when that happens, it's not like the president's veto where the veto goes back and they have to repass the law. According to our custom, when the Supreme Court declares a law of Congress unconstitutional, it is void. It is as if it had never been passed. And the understanding is Congress cannot pass a subsequent law in violation of that decision. Does that make sense?
Yes.
Yes, sir.
All right, let's finish actually with the last, and that's Jefferson. So, Jefferson thought this was baloney. What did Jefferson think of this? Actually, Sydney, since you're right there, or
I can read it.
Sabrina, do you want to read?
Yeah, I can.
So this is in the little piece against judicial review in the Nichols Reader. What did Jefferson think?
Do we start from the
Yeah.
Okay, so what is judicial review here? The power of the court over its own legal standards, a way maintaining its own constitutional independence. Judicial review would appear to be the power to ignore as a legal standard for the resolution of cases and on purpose.
Now that was my summary of the meaning of the case. Now, what was Jefferson's position on this? And remember, Jefferson never thought judicial review was constitutional. Go ahead.
The anti-judicial review position from the founders. The Supreme Court does not have the constitutional authority to judge the constitutionality of the Congress or the President. Either each branch should decide the constitutionality of its own.
That was his first and preferred position. What does that mean? Who determines the constitutionality of Congress's acts?
The Supreme Court.
No,
The President.
Congress does. Who determines the constitutionality of the President's acts?
The President.
And who determines the Supreme Court's constitution? So in other words, Jefferson says there is no final authority over constitutionality. Each just now, take 2 seconds and tell me what the problem with that position is.
They can
You said
say
what?
it's constitutional and it's not, and they can pass any law they want.
Wouldn't that be a mess? I mean, seriously, you'd have to say, doesn't one branch have to have the final authority? And for Jefferson, what's that branch, Sabrina? All right, okay, go ahead. Who should determine Congress's constitution? Who should determine the act?
The legislator given popular responsibility should have this power. Otherwise, the judiciary is elevated to a position of supremacy in the Constitution when in truth all branches are equal.
So for Jefferson, if one branch has to decide constitutionality, who is it? Because they are elected by the people, and this is a republic. That is not the position that is won out, by the way. All right. So we'll continue this on Wednesday. Yes, Tiffany.
So why are they deciding to overturn Roe v. Wade if it was decided in a higher court?
I'm sorry.
Why are they deciding to overturn Roe v. Wade if it was decided in a higher court?
They moved the chair just at the time when you finish it. One more time.
Why are they deciding to overturn Roe v. Wade if it was decided in a higher court?
It isn't decided in a higher court. It was decided by the Supreme Court in 1973. Mississippi passed the law knowing that somebody was going to challenge the law, and it has been challenged, and the Supreme Court is going to take that challenge this week. Only the Supreme Court can overturn a prior Supreme Court's decision.
Okay, so it's just their choice.
Yes.
Okay.
So literally, that's what they're going to have to decide. They're going to decide either to uphold the precedent, in which case Roe v. Wade will stand, because that means that, and several Supreme Courts have now decided that, but every Supreme Court is a new Supreme Court. And now that there are 6 conservative judges, President Trump appointed 3 judges, and most of the conservative judges are opposed to Roe v. Wade because they think it was a bad decision and a bad reasoning. So the reason that this case was brought was because now there are 6 to 3 judges who are likely to overturn, who are likely to conclude that Roe v. Wade was unconstitutional or incorrectly held.
Okay.
That's why.
I thought that's why. I just wanted to.
That's why. See you later.